Please join me in welcoming our speakers today from BSA Ahmed bin Hazim and Associates as they discuss this pertinent topic. Our first speaker is Rima Mrad, partner at the organization. Rima has over 16 years of experience working in the UAE and leads a team focused on corporate, M&A and commercial matters, AML and TMT. She has assisted and consulted various large corporations in the Middle East on their commercial activities and ventures and supported various UAE government authorities in the UAE on the introduction of new and revised regulations. Rima has lengthy experience advising various local and multinational financial and insurance regulated companies and oil and gas conglomerates on their overall business model and structuring of their operations in the region. Our second speaker is no stranger to the insurance industry. Simon Isgar has almost 20 years experience representing international insurers and intermediaries throughout insurance markets globally. Previously the head of corporate and regulatory insurance MENA at Kennedy's, Simon joined the BSA Dubai office as partner and head of insurance reinsurance in 2018, where he undertakes both contentious and non-contentious insurance and reinsurance work. Simon also leads the firm's Middle East cyber response team, working with Munich Re and several cedent insurers. His professional memberships include DIFC Insurance Association, British Insurance Lawyers Association, and the IBA. Dear delegates, I present to you Rima Mrad, followed by Simon Isgar. Please note that while using the platform, you will have the option of sending in additional questions in the question box on your control panel. I advise you to send questions relevant to our speakers. These will be discussed towards the end of the webinar. Over to you, Rima. Thank you.
Thank you, Lucy, for this introduction, and thank you for the attendees for attending this session. We will discuss today the AML regulations and their impact to the insurance industry. There is no doubt that over the last 2 years, there has been a lot of changes on the AML legislation front. We have seen the introduction of various regulations, and we have also witnessed the change of trends in the way regulators, supervisors, and financial institutions are dealing with customers and consumers. During the presentation today, we will go through various aspects of the AML regulations. Initially, I'm going to discuss the purpose of this webinar so that the attendees can understand better what we will be going through during these slides. We will basically explain the general regulatory framework relating to anti-money laundering and the counterterrorism financing and sanctions. We will see that these 3 items are commonly joined in the way legislations deal with AML. So whenever we talk about anti-money laundering, we hear the words counter financing of terrorism and sanctions. And this is at the recommendation of various international organizations, which have directed that the regulations relating to money laundering deal as well with the financing of terrorism, and also address the aspects of how sanctions can also affect the implementation of money laundering regulations. We will also introduce the attendees to the different authorities that have implemented regulations related. These authorities have been introduced recently between 2020 and 2021. We will also explain the various obligations with respect to compliance and sanctions, and eventually we will outline the details of what constitutes a risk-based approach system. The session today will be split into 6 main titles. The first one will be the overall regulatory framework. The second will talk about the main regulatory authorities, as we have mentioned. The third one will explain the risk-based approach. The fourth will go through the mitigation of money laundering and financing of terrorism risks. And these mitigation suggestions or elements will be based on the Cabinet Resolution number 10 of 2019 that was issued in implementation of the main UAE AML law. We will go through the sanctions and what are the obligations of insurance companies when it comes to sanctions. And finally, we will give some examples as to what constitutes standard high-risk situations in the regulatory framework. In this session, we will explain, or we will go through the main legislations that deal with AML, CFT, and sanctions in the UAE. And the most important law that deals with this is the Federal Law number 20 of 2018 on anti-money laundering and combating the amended in 2018, and that was the latest version following number of amendments between in the last 5 years. So the UAE authorities did amend this law regularly in the last 5 years. The last one and the most comprehensive draft was issued in 2018 under Federal Law number 20 of 2018. The importance of the revisions made is that they addressed specifically that highlighted in the FATF assessment and the requirements in order for the UAE to comply with international standards in respect of AML. So the new law did address the definition of money laundering, financing of terrorism, and financing of unlawful organization in a very clear and a specific manner. They have outlined the situation of when a person is guilty, and they have differentiate between money laundering and financing of terrorism. The law also identified the public prosecution as the party in charge of initiating proceedings against offender of money laundering and terrorism, financing of terrorism regulations. And this is like a milestone in respect of the identification of the powers of the different authorities that are in charge of implementing the AML law. The public prosecution is today the authority in charge of taking legal action against the parties that are in breach of the AML law. And this does not restrict the authority of the supervising authority in implementing penalties. Penalties and fines for administrative breaches are dealt with separately from the AML law. The public prosecution obviously will take the matter investigated, and following that they will decide to press charges or not. If they press charges, the matter will be referred to the court. Today we have specialized public prosecution in AML, and also we have specialized court in AML. So the UAE introduced recently the AML courts, which are basically in charge of looking into the cases involving breaches to the AML law. The public prosecution in each emirate of the UAE, we have the financial public prosecution, and sometimes it's referred to as the AML public prosecution, which are in charge of investigating files relating to AML and financing of terrorism. The importance about this law is that it also identified the assets that can be confiscated. This was something that was not very clear in the previous laws. Funds and proceeds obtained from the commission of the crime of money laundering or financing of terrorism or unlawful organizations, or property of corresponding value can be confiscated, and property and equipment and tools or instruments used or intended to be used in the crime. So basically this is the scope of what can be confiscated in the context of assets relating to AML crimes. The importance of this law is that it also identified the various sanctions that will apply in case of breach, with jail penalties going up to 10 years and fines going between 100,000 and 500,000, and sometimes up to 1 million. The law also created the Financial Intelligence Unit at the Central Bank, known as the FIU, which is currently part of the Agreement Group. The creation of the FIU also came as part of the recommendations that were issued by the FATF. And when we mention FATF, we mean the Financial Action Task Force. The Financial Action Task Force is an international organization. It's a non-profit organization. It was created by the G7, and its job basically to issue recommendations and assessment in relation to AML. They do assess countries and their compliance with the international standards, and their assessments are not obligatory or compulsory, but in a way they are referred to and used as a basis by banks, financial institutions, EU, US, and various leading countries in the world as a benchmark to rate the AML risk of a country and the interest rates that will apply on them, and so on and so forth. So the creation of the FIU was very important, and the FIU now being part of the Egmont Group will enhance the ability of the UAE to share and exchange data with other FIUs. The Egmont Group is a group that contains all the FIUs in the world, and basically they use it as a platform to share data and information, typologies, trends, latest trends, and stuff of that sort to enhance their ability to make efficient investigation and to share data where possible to crimes that involve more than one country. The last major development that happened following the introduction of this version of the AML law is the introduction of the corporate liability. Companies under the UAE AML law are liable, and they can be prosecuted if they are involved in AML and CFT, in money laundering and financing of terrorism crimes. The second law that's equally important is the Cabinet Decision number 10 of 2019. These are the implementing regulation to the law, to the Federal Law number 20 of 2018 on the criminalization of money laundering and combating the financing of terrorism. The importance of this Cabinet resolution is that it also provided a detailed approach to the way financial institutions should handle their AML obligations. The draft of the law in itself is very concise, but when we go to the Cabinet decision, we can see that it's much more detailed. It does go through the identification of what constitutes a financial institution, and insurance activities are listed as a financial activity under the definition of financial activities. All insurance activities that are covered by the Federal Law number 6 of 2008 on capacity. So basically, all of the insurance activities regulated by the insurance law are automatically considered as financial activities. So whenever we speak about financial institutions under the law, indirectly they include insurance and reinsurance companies. The main importance of this decision as well is that it identified the DNFBPs. You will hear more about them. They do not necessarily be relevant to insurance companies. DNFBPs are designated non-financial businesses and professions, and they include law firms, audit firms, and all traders of high-value items like art galleries, jewelry traders, companies trading in jewelry, and companies trading in high-value items like luxury cars, and so on and so forth. So all of these activities have been also regulated by the AML law, and they have been classified as DNFBPs under the Cabinet resolution, and they have identified what basically constitute the activities that should be regulated in the context of the AML law. The Cabinet decision also identified the AML risks. They went through all types of AML risks and how corporations should approach the identification of AML risks and the plan to mitigate the AML risks. The plan basically is very standard when it comes to the titles. We need to talk about the customer due diligence that we will go through in due course, the other administrative and policies and internal policies that they need to put in place to ensure that they have the appropriate resources and platform to address their AML risks, and the relationship with PEPs, politically exposed persons, the submission of suspicious transactions reports, and so on and so forth. The Cabinet decision also elaborated extensively on the role of the FIU in terms of their capabilities, capacities, what could involve their power, what could be involved within their powers, and at the same time, they talked about the way the FIU could communicate with the supervisory authorities in order to regulate a certain sector. And when we talk about supervisory authorities, we have various supervisory authorities in the UAE. It depends on the activity of the company, basically to decide which authority is in charge of supervising its activities. For example, for financial institutions and insurance companies, the supervisory authority is the central bank. For companies that are incorporated in the DIFC, the supervisory authority is the DFSA. For companies incorporated in AGGM, the supervisory authority is the FSRA in AGGM. For law firms and other DNFBPs, it could be either the Ministry of Justice or the Ministry of Economy, and so on and so forth. So you have various supervisory authorities within the UAE itself, and they communicate regularly with the FIU in relation to certain obligations and to enhance the application of the AML law. The UAE Central Bank today is the main regulator of the insurance-related activities in the UAE, and this happened following the merger of the insurance authority with the central bank in 2020. That decision finally discussed and elaborated on the UBO, ultimate beneficial ownership, and how to establish ultimate beneficial ownership and confidentiality undertakings, which we will also go through throughout this presentation. These are basically the most important two pieces of legislations relating to AML in the UAE. And apart from this, we have several other legislations that we frequently consider as important in the context of AML, including the penal code, the criminal procedure law. The penal code basically addresses all the crimes that are punished by the UAE from a criminal perspective and their relevant penalties, including jail and fines as applicable. That in many instances, AML crimes can be combined with other crimes that are covered by the penal code. In addition to this, the criminal procedure law will apply to the procedures that are followed before the AML courts. The criminal procedure law does identify the formalities relating to the submission of the cases, the hearings, and so on and so forth, evidence, and all of these. And they do form an integral part of how AML cases are handled by the AML courts. The other laws that would be relevant are the cyber crimes, the combating of terrorism offenses, and the terrorism lists regulation and implementation of UN Security Council resolution. Both of these addresses specifically terrorism-related offenses, and the UAE have issued separate laws to deal with that. The law number 7 of 2014 on combating terrorism offenses is a very concise and straightforward law, and it does address the specific crimes that could be considered as terrorist offenses. And the crimes are very well identified in terms of the role or the involvement, and basically how could this be construed as a terrorism crime. And as I said, the law is very concise in this respect because it does go directly to deal with the identification of the crimes and the respective penalties. The Cabinet Decision number 74 of 2020 regarding the terrorism lists regulation and implementation of UN Security Council resolution. This also came as a confirmation from the UAE to the implementation of the Security Council resolution. And following this specific decision, the UAE made public their local terrorism lists and the UN security lists, which can be accessible now through the website of various government authorities. And finally, the most important recent legislation issued in a way to reinforce the implementation of the AML law is the Cabinet Decision number 58 of 2020 regulating the beneficial ownership procedures. I believe the majority of companies have had to deal with this in a way or another because these procedures under this law, all companies were required to identify and file for the details of their ultimate beneficial owners. And it was not enough to disclose the name of their shareholders. It was necessary to identify the ultimate beneficial owners. If the companies were owned by companies, they need to disclose up to 20, they need to disclose the details of the individual shareholders holding more than 25% of the ultimate corporate shareholders. So the purpose of these legislations was to also have a clear record of who are the shareholders of the companies established in the UAE and to ensure that none of them is under any sanctions lists. The supervisory authorities again handled the implementation of this law, and we have seen Dubai economy taking various steps, and Ministry of Economy as well, taking various measures to reinforce the implementation of this decision, including issuing fines of up to 50,000 dirhams for failure to file these disclosures on time. In addition to the federal laws that we usually know, the UAE Central Bank is also very active in issuing circulars relating to money laundering and the financing of terrorism. The main three circulars they've issued, or the main three documents they've issued in this respect. The first one is the procedures for anti-money laundering and combating the financing of terrorism and illicit organization. These procedures confirm the authority of the central bank to impose administrative penalties and to supervise and examine financial institutions' compliance with the regulations. This could seem very, very basic to you, but the main challenge that the central bank used to face in the past days, it was restricted by law from issuing administrative penalties, or it was to a certain extent restricted by the fact that any administrative penalty they may impose could be appealed at a later stage. And this, in a way or another, weakened the ability of the central bank to foster its supervisory and enforcement powers. On that level, they have amended the law, as we said, to increase the powers of the central bank, but also they have issued these procedures to confirm today that the central bank has the full authority to impose administrative penalties that cannot be appealed in many of the instances, and also to confirm that the central bank is the authority in charge of supervising and overlooking the compliance of financial institutions and insurance companies with the AML regulations. Again, this sounds basic, but unless we have a clear text of law, we cannot justify the authority of the central bank to do these kind of obligations. That's why it's essential that we have a clear text dealing with this from a legal perspective. The second set of guidelines that are equally important are the guidelines on anti-money laundering and combating the financing of terrorism and illegal organizations. These guidelines basically provided a comprehensive set of notes and remarks on how corporations and financial institutions should deal with their assessment of risks. How do they handle their customer due diligence? What are the minimum requirements? They have identified, as we say, the do's and don'ts. And this is a very good document that companies should refer to whenever they are developing their AML guidelines, because it will help them ensure that they are fully in compliance with the regulations. We are expecting the supervisory authorities also to use these guidelines as a benchmark, so that whenever they go and check the situation of corporations and their compliance level, they will cross-reference their current assessment with whatever that's included in these guidelines to decide on whether or not they are compliant. Finally, the central bank issued the AML CFT guidance for licensed financial institutions on transactions monitoring and sanctions screening. And both of these deal specifically with sanctions in terms of handling how transactions monitoring should happen, and program governance and oversight internally within the corporation. So these are basically the main important local legislations relating to AML. When we go to the international legislative framework and within the context of AML, we need to know that four authorities are very key when we talk about AML. The United Nations. The United Nations is one of the major organizations in the world that issues sanctions, and their sanctions are compulsory and obligatory on all member firms, or all member countries, sorry, on all member countries. The UAE is a member of the United Nations. On that basis, they are obliged and required to comply with the United Nations resolutions, especially the ones issued in the context of sanctions. So any country or organization or individual that is sanctioned by the United Nations should be sanctioned by all member countries to the United Nations. In addition to this, we have the FATF and the MENA FATF. Both of them, they are, as we said, non-profit organizations. Their job is to do assessments of the AML systems of countries and issue recommendations. They frequently issue recommendations on how to deal with AML within certain sectors. For example, they have worked on the insurance sector, on the life insurance sector, and they have identified the most common risks that could be evident in this sector, for example. And finally, the Egmont Group, which contains the financial intelligence units of the world, and where they share information and data to enhance their investigation capabilities. This is with respect to the first section. In the second section, we will talk about the main regulatory authorities in the UAE. And it's also relevant to talk about the main regulatory authorities because we do believe that it's very key today to know the new authorities that have been established in 2020 with a mission to implement various aspects of the AML law. We will go through them so that you can get to know them. The main authority obviously is the UAE Central Bank. And the UAE Central Bank became more relevant to the insurance industry or to the insurance sector in 2020 after Federal Decree number 25 of 2020 was issued to confirm the merger of the insurance authority into the central bank. The central bank is mandated to ensure the financial stability and consumer protection within the insurance sector. So their capabilities and their supervisory role will get wider in the coming years. We understand that the merger happened in the middle of COVID in 2020, and this, I believe, did not fully empower the central bank to conduct whatever they were looking to conduct in terms of changes to the insurance industry, to the regulations that are in place, to the consumer protection regulations relating to the insurance industries, and so on and so forth. But we are expecting this to change in the coming years as soon as the central bank is more able to focus on this post-COVID. The central bank should also confirm, basically, that all the decisions and circulars that were issued by the insurance authority will continue to be valid and enforceable until they issue replacing regulations. So as long as the regulations have not been replaced, whatever that has been issued under the law number 6 of 2007 on the insurance authority will continue to apply. In addition to the central bank, we have the National Committee for Combating Money Laundering and the Financing of Terrorism and Illegal Organization, the AML CFTC. This is one of the bodies that were recently established, and their job basically is to prepare and develop a national strategy to combat crime and proposing related regulations, coordinate with the relevant authorities to identify high-risk countries and their adherence to customer due diligence, facilitating exchange of information between the various authorities, collecting and analyzing statistics to assess the effectiveness of the regulations on AML and CFT, and representing the UAE in international forums. The National Committee include members from different ministries. We have members from the Ministry of Foreign Affairs, from the Ministry of Interior, from the Ministry of Finance, from the Ministry of Justice, from the Ministry of Economy, from the Central Bank, from the Securities and Commodities Authority, from local police department, and other authorities. And the purpose of this is to create a platform for all the supervisory authorities that we have mentioned to basically be able to share information, consolidate their efforts where needed, and ensure that like all these authorities are working under the same platform within the same goal and expectations. So this effectively enhanced the coordination and communication between the authorities to handle their responsibilities. The website for the National Committee for Combating Money Laundering and the Financing of Terrorism and Illegal Organization has been also introduced recently, with a lot of information data available on it. In addition to this, we have the Committee for Goods and Materials subject to import and export control. This has also been established very recently, pursuant to I think there's a mistake with the number of the resolution. It should be 2019 instead of 2009. It's wrong on the slide. This basically, this UAE cabinet decision or resolution established the Committee for Goods and Materials subject to import and export control, and they have also created the executive office to act as a communication channel with other countries and international bodies. The executive office has a lot of powers in terms of sanctions, enforcing sanctions, overlooking sanctions, and so on and so forth. And the website of this committee is very active in terms of having direct access to the different goods that are controlled now and that requires a license to be imported. So you need to go on their website to be able to see what are the goods and materials that are construed as controlled materials and what are the procedures to obtain a license for these. Through the website as well, we can access the sanctions list, and all financial institutions have been required last year to subscribe to the website so that they can get updates on the sanctions list. So there's a quick link on the website that will allow corporations to go register, put their names, and this is one of the requirements to ensure compliance with the AML law. Without this registration, corporations would be construed to be in breach. We have also the Securities and Commodities Authority. I know as insurance corporations, you do not deal a lot with the SCA unless within the context of your listing. If your insurance companies that are created in the UAE are publicly listed, and on that basis they deal with the SCA, we are expecting the SCA to have a greater role in terms of creating more governance and transparency and enforcing these concepts within insurance companies in due course. Their role in respect of AML is restricted to a certain extent. Nonetheless, they have an obligation to monitor the compliance of SCA licensed entities with the provisions of AML rules and regulations, especially the ones that are directly licensed by them. Insurance companies continue to be regulated by the central bank, and that's why the supervisory authority of the SCA over insurance companies in the context of AML is not that good. Finally, we will talk about the GFSA and the FSRA. Both of these are the financial regulators of the free zones known as the IFC and ADGM. And both of these authorities, they have the right to enact and administer their own rules and regulations. What is to be known is that AML is a federal crime, and on that basis, it does apply inside the GFSA and inside ADGM. So disregarding the capacities and the rules and the powers of the GFSA and the FSRA, the authority of the UAE authorities, including UAE AML courts and the central bank, will continue to prevail in the context of the investigation and prosecution of AML crimes. And this is why we have seen that the UAE implemented the registration with the Go AML platform for reporting suspicious transactions, and this was required equally on all companies incorporated in the IFC and ADGM. Moving on to the risk-based approach, it's also a very relevant section of the presentation. In this specific presentation, we will talk about the risk-based approach in terms of how do we deal with it. I know for a lot of international companies, multinational insurance companies, or companies that are active in the EU, we have heard, or in the UK, we have heard frequently about the risk-based approach before. But what is to be known is for local companies and for the UAE as a government or as a country, the risk-based approach was introduced in the Cabinet Decision number 10 of 2019. And with this introduction, corporations had a new obligation to have proactive and comprehensive assessment of their risks and the way they deal with the AML risks, and the requirements to implement the risk-based approach provides for more than the standard requirements. Before the risk-based approach, companies were only required to collect certain data. So, and you will know this from yourselves, because when you went to open a bank account, the bank would only ask for your ID, and that's it. And most of the time, the bank will come to you, will get you sign the documents, and go and sign. Now the approach changed. Now the bank will call you to go, and they will need to see your ID. Now they will check your source of income. Now they will ask about your salary slips. Now you will ask about if you have received a payment that is not regular, they will ask about it. This is a way of addressing the risk-based approach that we frequently talk about, and these are the details of how it's implemented. under the previous system before the RBA, corporations used to feel comfortable collecting minimum data and saying that we've done our job without necessarily disclosing information that does not need to be disclosed. So as long as you were required to collect 1, 2, 3, you would collect these and you would hide any other information that could be relevant. Under the risk-based approach, this is no longer allowed. When you open a file for a client or when you deal with a client, any information that you know could be relevant to assess the risks of the client, and non-disclosure of this information could be construed as a breach. Again, the FATF notes that the risk-based approach means that supervisors, financial institutions, and intermediaries identify, assess, and understand the money laundering and terrorist financing risks to which they are exposed and implement the most appropriate mitigation measures. So again, they have introduced this system because they understood that companies are the best to know their clients. And for example, salespeople are the best people to know who they are dealing with because they deal with the client, they know them, they follow up with them, they see them in their offices, they know all their details, and they, on that basis, they are able to direct their compliance teams on how to handle the AML risk assessment of these clients. As we said, the risk-based approach is based on the following premises. Professionals know their clients and their business better than any government agency. Professionals will act in their own best interest by not engaging or being utilized for criminal acts, and by enabling professionals to direct resources to meet money laundering risks where they are the greatest. On this basis, the risk-based approach shifted the liability to the company and told them, you are in charge now of assessing the risks of your client. And if you have missed to assess the risk of a client, it means your systems are not good. And you need to change your AML systems to ensure that you have a system that will be able to allow you to identify whatever risks that your clients have a problem, are exposed to. Risk-based approach basically depends on 4 main elements. So whenever we are dealing with when we say RBA, we mean risk-based approach. Whenever we're dealing with RBA, we need to talk about 4 different types of risks that we need to address separately and jointly. Customers risk, product, services, and transactions risks, geographic risks, and delivery channel risks. We will go through each one of them in due course, but these type of risks were also identified very extensively in the Cabinet Resolution number 10 of 2019 and in the guidelines issued by the Central Bank on AML. Before we move to the identification or to the explanation of these risks, we need to know more about the main obligations of insurance companies in terms of doing their own business risk assessment. So all the guidelines that have been issued in relation to business risk assessment or risk-based approach, or the identification of risk-based approach, and the implementation of the proper pillars for risk-based approach, they have required from financial institutions and insurance companies, and also the NFPPs and all regulated companies, to do beforehand what we call a business risk assessment. Money laundering and financing of terrorism business risk assessment. And this business risk assessment will allow the company, the relevant company, to identify the ML and FT risks they face as a whole and determine how they can effectively mitigate these risks. And what do we mean by this? We mean, like, for example, an insurance company, before they go and develop their AML risks, they need first to develop their business risks. And to do so, they need to do an exercise of going through their activities, their customers, their products, what kind of countries they work in, and so on and so forth. And in each item, develop or explain. For example, for customers, explain whether they're dealing with individuals or corporations, whether they're selling life insurance, health insurance, or other type of insurance policies. Identify what could be the AML risks relating to each area. Like, for example, for individual clients, what are the AML risks and how could they mitigate them, and why they will be allowed to mitigate them. For a lot of corporations, for example, they only do car insurance. They can simply say, we only do car insurance for corporate bodies that are registered in the UAE. The AML risks on that basis will be very on a large scale would be very low. So they can explain this in detail to come up with a conclusion of their business risks assessment that clarify exactly what are the risks they are exposed to, and as a result of this, they can develop their plans. The result of this, as we said, the result of this business risk assessment exercise is that companies will eventually be able to identify their exposure and move from that basis to say where they rank high, where they can rank medium, or where they can rank low, and eventually develop their own AML policies and procedures and manuals. When it comes to the customer risk, like this is an essential part of the business risk assessment. The customer risks favors factors relate to type or categories of customers. Certain customer or business relationship categories may pose risks that are higher than others in different circumstances. So, for example, we need to look at the type of customers, whether the customers we deal with are individuals or non-individuals, whether they are high net worth or normal people, whether they are resident in the UAE or not resident in the UAE, and so on and so forth. The customer base also will have a great platform. We need to see whether our customer base is homogeneous in a way where they contain the same type of customers, or there is a possibility of receiving different type of customers, or the company does have appetite to receive different type of customers. There's nothing wrong or right in this context. All what we need to do to identify the accurate facts that we are dealing with and prepare a plan accordingly or address the risks accordingly. Finally, the maturity of the relationship. We need also to understand whether or not the client we are dealing with is someone we know for a while, or is a new client, someone that dealt with the company or another group company, and so on and so forth. All of these data matters. When we go to the geographic risks, it's also very important. The geographic risks expose us to other type of risks, including sanctions risks. The geographic risks will identify where do we do business as a company, where our client is doing business, whether they are active in any sanctioned country, whether they are coming from any sanctioned country. We need to look at their residence, country of residence, country of origin, country of nationality, and so on and so forth. So a lot of information will play a factor in the identification of geographic risks. And when we assess the geographic risks of a company, we go through where do we do business, or where do we accept business from, and whether or not we have appetite to receiving business from certain jurisdictions, and what are the mitigation plan we are proposing to handle these. And the geographic risks will be assessed in light, for example, of the jurisdictions, as we said, being on a sanctions list, having reputational problems with AML issues. They are considered as a gray area under the FATF, or as a gray country under the FATF, or non-cooperative country under the FATF, or whether they are known to have a very strong regulatory and supervisory framework. All of these will play a factor in addressing the geographic risk. Product, service, and transaction risks is also important. This will allow us to go through what kind of insurance products we are selling this client, and what are the risks associated with these products. Everybody knows in the industry that life insurance products and investment-related products are on an AML basis higher risk than the general insurance products, and so on and so forth. It depends on the payment of premiums, on the purchases and cancellation of policies, the number of policies we issue for the client, and so on and so forth. So these are very relevant. And with the introduction of every new product, we are required to take new procedures to address the risks associated with this product, or as relevant, update our business AML business risk assessment on AML on that basis. And finally, the delivery channel related risk. And by the delivery channel, we mean how we deliver the service of the product to the client. So basically, we know the client face to face. We have met with them. We visited their offices. We did not. We are dealing with them through the website. We are dealing with them by emails. We are working with a representative, and so on and so forth. All of these factors play a role in assessing the risks associated with the delivery channel. Obviously, face-to-face and ability to deal with the client himself or itself directly, visiting their offices, knowing that they exist is more low risk than anything else. Going through the mitigation of, to mitigate the risks we have assessed, we will go through the main 4 risks we always talk about: the product risk, the jurisdiction geography risk, the customer risk, and the delivery channel risk or the interface risk. These risks will always be present because any mitigation plan should also be based on each one of these and how they will work together. Eventually, for any corporations, they need to put in place specific plans to address money laundering and the financing of terrorism risks. And we will go through each of one of them today in the coming slides. Basically, if we go to the Cabinet Resolution number 10 of 2019, and if we go to the guidelines implemented by the Central Bank, we can see that both of these have identified clear steps to mitigate money laundering steps. These steps can be tailored per corporation or per company, but eventually we deal with the following. We deal with the customer due diligence. This is something very important that we need to put in place. In addition to the customer due diligence that we need to implement, we need to have appropriate procedures for reporting. We need engagement of senior management. We need certain training capabilities and so on and so forth. All of these together will create the appropriate internal policies and system to comprehensively address the money laundering and financing of terrorism risks. On the internal controls and on the CDD, the first item is the CDD, which also is the most important item, and that is explained clearly and in details under the laws relating to AML. Every financial institution, including insurance companies, are required to conduct CDD on their clients. And by CDD, we mean identify information about the client. And this includes identifying who is the customer, the ultimate beneficial owner of the customer, receive copies, corporate documents of the customer, like the memorandum of association, articles of association, licenses, and so on and so forth. Understand where the client is based, their headquarters, what kind of jurisdictions they're active in, what kind of activity or business they handle, and eventually all of this information will allow us to conduct an assessment of the appropriate risks that the client exposes us to eventually address the measures we need to take. The purpose, as we said, of the customer due diligence is to verify the customer and the UBO identification, and by UBO we mean ultimate beneficial owner, to understand the client business structure and UBO, especially in life insurance business, and by UBO in life insurance business we mean beneficiaries, and to check whether or not we have any PEP involved. PEP means politically exposed person. And based on this, we can decide whether to have an enhanced ACDD, which is the EDD, or a simplified CDD or SDD. In the case of high risk, so for example, we have verified the customer and the UBO, we understand the client business, we understand the client structure, we know exactly who owns the company, and we have a PEP involved. Whenever a PEP is involved, we need to understand whether or not the PEP presence will qualify the situation as high risk. If so, we automatically need to go into enhanced due diligence. And by enhanced due diligence, we need to collect more data, more information to be able to satisfy our compliance requirements. And the purpose of the collection of information is to ensure that our AML risk is low. So we ask the client for the source of fund and source of income to ensure that all the information relating to the file are very clear and transparent. We go further into the validation of all the information we have collected, and so on and so forth. If, however, we have verified the information and we came to know that the company is a publicly listed company, all information are available online, no PEPs are involved, then obviously we can implement the simplified due diligence procedures, and these can reduce the amount of monitoring and that we need to conduct on the file throughout the relationship with the client, and at the same time reduce the amount of information that we need to collect from them. In the context of life insurance, specific CDD is required, and this includes, by way of example, identifying the beneficiaries, and identifying who is the beneficiary by name. Wherever this is not possible, we need to identify, for example, their capacity or their capability. And if so, we need to ensure that the team or the people on board have all the minimum information required to be able to assess the identity of the person when needed. This is basically in respect of the life insurance. Life insurance is one of the highest. As we said, for life insurance, it's really very critical and technical, because in the context of life insurance, we have so many parties involved. We have the one that will issue the policy, and we have the beneficiaries. And in many instances, the beneficiaries are not identified until the time when we make the payment to them. And on that basis, the obligations in relation to AML will not stop at the time when we issue the policy, but will be ongoing throughout the life of the policy, whenever we have a change of beneficiary notice, or whenever we have any change in the details of the policy issuer, and finally at the time when we make the payment. So this is very relevant in the context of insurance policy, and these are additional CDDs that are required in this context. Always the verification of the identity of the beneficiaries should occur at the time of the payout. It does not exclude the fact that we need to validate the identity throughout, but it's very important to do that. And this is not from an AML risk as much as it is from a sanctions risk. And this is more relevant for corporations that have presence outside of the UAE, especially the ones that are active in the US, because OFAC sanctions, for example, do apply in this respect, and they need to know, and sanctions risk should be conducted on real-time basis, which means at the time when you are making the action. So you cannot do the sanction risk today and then overlook the screening throughout the relationship. The screening should happen on real-time basis at the time when you make the payment, or at the time when you specifically take an action in respect of the fine. And this may mean that the screening can happen more than one time. Inability to make the appropriate checks could justify the filing of a suspicious transaction report. So it depends on what are the procedures that are implemented within the corporation. But whenever you feel that you are unable to get the information from the client for any reason whatsoever, you need to consider filing an STR. In addition to this, the ability to qualify a file as a high risk could mean that we need to do an ongoing monitoring. And by ongoing monitoring, we mean we need to regularly check the information. So for example, it's recommended for high-risk files to check the validity of the information we have on record regularly. And by regularly, I mean every 3 months, every 6 months, depending on what internally they will decide. And the monitoring could address different things, but mainly they can relate to any change in the information of the client, any change in their activities, any change in the parties we deal with, or any change in the nature of service we provide the client with. There are different benchmarks that we can use for ongoing monitoring. Like we can say, whenever we reach a certain income with this client or certain revenue from this client, we will do another screening. Or we can say, whenever we have certain jurisdictions involved, or like, for example, whenever the client deals with Iran, I need to do additional screening. This can also work. Customer-based rules, whenever there is a change in the customer identity, information, address, office, owners, shareholders, management, all of these will matter. And finally, on transaction-based approach, which means whenever there's a change in the nature of work we are doing for the client. So all of these thresholds can be used, and usually the compliance team will be the one deciding on how this will be handled. Suspicious transaction reports are also an essential part of the AML obligations. This will mean that any company that deals with a situation that could be seriously suspicious, and by this we mean they have grounds to believe that they are dealing with a situation where the proceeds relate to a crime, where there is an attempt or intention to use the funds or the proceeds for the purpose of committing or concealing or benefiting from a crime, the company must file an STR. Today, the UAE have unified the system of filing STRs through the Go AML. All regulated companies, financial institutions, insurance companies, and DNFPPs are supposed to have Go AML registration. And the Go AML platform is like a platform where you can file STRs, receive notifications from the authority and the central bank on this, and usually they share the national risk assessment with companies through that platform. The national risk assessment is very relevant. The national risk assessment is the UAE assessment of the country from an AML perspective. And this is a confidential document shared strictly with financial institutions and regulated companies. And the purpose of this is to allow these companies to understand what are the risks that the countries are exposed to in AML, in terms of AML, and what are the latest trends or like techniques that criminals are using in this context. Finally, a failure to report an STR, a suspicious transaction, could involve a fine of 100,000 to 1 million and imprisonment in such instances. This is very critical and technical because the failure to file an STR sometimes could be construed as cooperation with the criminals. So this is why it's very technical. In addition to the implementation of the appropriate notification system, the laws will require from corporations to have a compliance officer and to ensure governance. Having a compliance officer, the job of the compliance officer is to ensure that they are able to report on AML and CFT, they are able to implement the program within the company and to provide training and development where needed, and to act as a point of contact with the supervisory authorities and regulators. With respect to governance, they emphasize on the need of engaging senior management. What do I mean by government? Today, it's compulsory by law that senior management is directly involved in all compliance mechanisms, initiatives, and deficiencies. They are required to sign on reports relating to the business risk assessment, and they are required to be part of the systems that's implemented internally in relation to AML and CFT. And senior management are indirectly or in fact directly construed as responsible. They cannot avoid liability by saying we did not participate in the decision making relating to this, or we were not part of this. Their presence on the senior management is in itself a reason to hold them liable for the proper implementation of the AML related regulations. Finally, the two other areas that are very important in the context of the mitigation is staff training and record keeping. Staff training is to ensure that all the employees within the company, or the main employees that deal with clients, have minimum understanding of money laundering and financing of terrorism risks. And by this we mean we conduct an annual training for the people to understand what they need to do, what are the policies that are implemented within the company with respect to AML, and what are their requirements. Training is very relevant because unless the employees are aware, the compliance and senior management alone will not be able to do the job. They need the team that are handling, or the team that are dealing with the client to be able to address the AML risks accordingly and to share the relevant data with the other team where needed. Record keeping is also a requirement by law to enable the supervisors to ensure that they are able to identify or validate the checks that have been done. Record keeping for corporations is for a minimum of 5 years, depending on the circumstances, but the date to start can be construed, like the law provided for different events to start the 5 years term. This including, for example, termination of the relationship or closing of the account, or for example, completion of an occasional transaction if the client is not a recurring customer, completion of an inspection on the record by the supervisory authorities, the issue date of a final judgment by a court of law, or liquidation or dissolution of the legal person or arrangement. 5 years from any of these dates could be construed as the minimum or the required retention period for any and all AML records we have on file. Final sanctions. Sanctions is very important. We always deal with sanctions separately from AML, despite the fact that a lot of people confuse both of these areas. Sanctions are totally different from AML in terms of the requirements and the way to screen them and the way to handle sanctions. Unlike AML, we need to work on them respectively before we start the relationship, when we start the relationship, in the middle of the relationship, or throughout the relationship, and at the end. In the sanctions context, we need to work on real-time basis. And by real-time basis, we mean when we do the transaction itself, when we press the OK, for example, we're writing a policy for someone. At the time when we're issuing the policy, we need to run a screening on the sanctions. At the time when we're paying the policy, we need to run a screening on sanctions, just to ensure that we're not in breach of sanctions regulations. The UAE basically is obliged to enforce the UN resolutions on sanctions, which are issued under Chapter 7. All member countries, as we said, of the UN are required by default to implement the sanctions decisions issued by the UN. Apart from the UN, the UAE does not enforce the OFAC or EU sanctions by default. Nonetheless, corporations that are active in these jurisdictions are required to get advice as to how they need to deal with their exposure to secondary sanctions from these jurisdictions when they do business in the UAE, especially when it comes to OFAC sanctions. It's important to note that the UAE formulated their approach in relation to sanctions through the website of the Committee for Goods and Materials subjected to import and export control, and through the website of the committee now, we can have direct access to the list of local sanctions and the list of UN sanctions. Usually corporations can do online screening if they have subscriptions with certain platforms, while if they don't, they can do manual screening. And these lists will enable them to do this manual screening easily. There are various requirements or obligations of corporations in the context of sanctions under the UAE laws, and these includes basically companies are required to register with the executive office, as we said before, to receive notification. This is a compulsory requirement, and it has been required in several reporting filings with the supervisory authorities. Companies are always required to screen their records or their clients to the list, and also implement the targeted financial sanctions by either freezing funds or prohibiting making the funds available whenever we are dealing with a sanction. The specific obligations on this is that financial institutions, including insurance companies, they are required to report within 2 business days from taking any freezing measures or attempted transaction to the relevant supervisory authority. So it's a short timeline, but it's compulsory. And also individuals must notify within 2 business days from taking any freezing measure or attempted transaction to the executive office. What should be known as well is that if by mistake and it turned out that this freezing was incorrect, however, they did it in good faith, the liability is waived. And this is a text of law to fully enable the proper implementation of the sanctions regulations. The main obligations of corporations in relation to sanctions, basically, as we said, include implementing the freezing cancellations decision. So whenever we have a freezing decision or a freezing cancellation decision, the companies should be able to immediately react to that and take the necessary actions, immediately notify within 2 business days whenever they are dealing with a freezing action or cancellation of freezing action, implement internal controls and procedures to be able to ensure compliance with the obligations arising from the resolutions relating to sanctions, and finally implement policies and procedures and cooperate with the supervisory authorities in verifying their data. So whenever they are dealing with a sanction situation, they need to report, but in most of the instances, the authority will get back to them asking for more information. There is a requirement by law to cooperate and to provide all data available. Confidentiality protections that are granted under any type of law in the UAE, including relationship between lawyer and their client, is waived under the application of the AML and sanctions law. So this will relieve anyone who could use confidentiality as a basis to justify disclosure. Finally, we have three different authorities in the UAE in respect of sanctions. We have the supervisory authorities, which they do provide information, supervise, and apply enforcement actions like fines. And we have the enforcement authorities, which implement the decisions taken and communicating the same to the companies in charge. And finally, we have the Executive Office of the Committee for Goods and Materials Subject to Import and Export Control, which also is acting as a point of contact for the central authority to implement sanctions, report, receive applications, receive grievances as well. Whenever you, like for example, you have been put on the sanctions list and you need to appeal, you go to the executive offices for that purpose. Obviously, this is whenever we're talking about local sanctions lists. Work closely with the authorities, supervisory authorities in the UAE, different supervisory authorities to fully implement the sanctions regulations, circulate updates, and coordinate information with the different government agencies. It's very critical, the role of the executive office. We have seen that although they have been incorporated recently or established recently, they have taken a lot of responsibilities in the past year, and companies were required on various fronts to actively communicate with them, subscribe with them to be able to stay on alert of the changes. This is basically when it comes to sanctions. I think I'm done. I tried my best to be on time. I believe I ran a little bit more than what I should. I'll pass on the screen now to my colleague Simon. He will discuss, or he will give practical examples for insurers, what to look out for. And I believe it will be best to address the questions in the last section.
Thank you very much, Rima. That was excellent, as always, in terms of an analysis of the law, and to really look at the practical aspects and what you would need to look for in terms of the products, the customer base, the geography, and how those products, for example, are placed. What is interesting, there is a misconception in the reinsurance market that you know, money laundering offences don't really happen, or there's not that many that happen, and it's all to do with banks and investment companies. But actually, last year there were, in the US alone, over 62% of insurance and reinsurance companies recorded money laundering offences. So it's quite a serious issue. It's become more prevalent here in the UAE, as Rima's explained, in terms of the very fragmented sort of legal framework that we have. We also now have a unified regulator, so central bank, which is obviously important in the sense that this has the overall reach to money laundering in terms of controlling and regulating that. So that's very important as well. Rima also addressed a very interesting subject, which is the risk-based approach, which is often seen in other markets, as in Europe, in the United Kingdom. We have, to a small extent, have the risk-based approach here through the financial regulations, but it's a foreign concept for this market. But it's all to do with the fact that, you know, as insurers, reinsurers, you know your business better than others, and you are therefore you should know what those risks are and have your systems controls in place. So that's also a very important aspect as well. So what I'm going to do, as I said, I'm going to move on really and just give you some examples of some products. Rima's sort of touched on it slightly about which types of products that may cause or may be prone to money laundering, where sort of dirty money can be washed into clean money. And those are mainly seen in the life products with investment. So what one really has to look out for, that you'll appreciate that with the life market globally, there are massive funds flows that run through those markets. And a lot of those are tend to be sort of products with high investment elements, which have some value as an asset. And you'll see here I've given some examples of how one could facilitate money laundering through these products. So, for example, we've got here a single premium policy that could be a one-off payment for a life investment product, which could be easily filtered to sort of put dirty money through. We look at transfer of ownerships. As you all know, policies are assignable. There is a market where those policies are assigned to criminal gangs where they can wash money through. Another example is annuity policies. They, as you know, derive a legitimate income, but again can be policies that could be washed through. We have policy loans. So there is a market, of course, for facilities and loans taken against the asset value of a life product, for example. And that's often used for anti-money laundering. There's seen a rise of that in the United States, as is the collateral as well for a single premium policy against bank loans. So all of these are potential vehicles, as it were, for money laundering. There is also another interesting one here, what I termed of as cooling off periods. We term that here as free look periods. So that's essentially where the policyholder has the right to cancel the policy within a certain period of time. Here under the life regulations, it's 30 calendar days. That presents obviously potential for money laundering offences where large payments are made and then refunds are made to clean it through the system, as it were. So be aware of that. Policy surrender as well is another one, which deposited a loss. And then we have what I term here a secondary life market, where policyholders are in poor health. They will then sell on those policies to third-party criminal gangs, who will then become legitimate owners of those policy terms. Another one is, of course, top-ups, small amounts of premium paid over a period of time to avoid any attention of the regulators and the authorities and the enforcement authorities. Those are other aspects one would need to look out for. So what should insurers and reinsurers think about in this rather technical legal framework here we have now with anti-money laundering provisions? The insurance model here is quite interesting because there are many counterparties involved, as you know. We have a local cedent insurance company that may work with and often do work with insurance brokers. Many cedent insurers also have their own exclusive agents, and then there'll be other third parties that they're involved with outsourcing. So it's quite key to realise that working with these third-party insurance brokers, agents, that they need to be part of the overall money laundering programme for the insurer and reinsurer. The obligation, of course, is with those individual insurance brokers, agents, to carry out their own customer due diligence, their own sanctions checking. But you, as an insurance company or a reinsurance company, will have also an obligation to check your third party, your counterparties that you work with as well, to check that they are also all in line. And that's normally done through sort of contractual procedures, terms of business, and so forth. Also, the other interesting thing is that it's not just an obligation before inception of policy. Anti-money laundering checks should be carried out throughout the life of the policy and the ongoing period of the policy. So on renewals, for example. So it's an ongoing obligation, not just before the policy is incepted. And specifically where we see large risks here is really around these one-off large premium payments, and then refunds are normally given. They tend to be, as I said, more in the life side of the business, some in medical as well. We come across, and they can of course be in other lines of business, but tend to be where the investments are and where high payments are made and refunds are made. So just looking at some practical examples for insurers. So we put here, this is to do with, of course, the product risk, and this is some guidance that's been given here for specifically around the life insurance market. And if we just quickly look at the sort of low risk, it talks about product design that does not hold balance or can't be withdrawn against. So we set that against a high risk profile, which is a product design that allows funds to be held on behalf of customers. Those funds are high value, unlimited value premium payments, overpayments. That's another common feature with money laundering offences in insurance. Overpayments of premium are made. I've certainly come across this when I've been advising some clients in the life market, and then those refunds are made. So be aware of that. We look at here at the customer anonymity and third-party transaction. So product design is also important in transactions, where you can identify the customer and identify where those funds flow back. That would be seen as a low risk. Where the product design and the payments to third parties, and there's non-facing transactions, those are, of course, can be very high risk. So someone, for example, might act as a third party for a policy holder. There also might be a beneficiary relationship, so they can also present high risk to some extent. Then we have a look at the liquidity. So you have your product design, which includes this, significant penalty or unworthy resource. So those are things like redemptions, where there's a call in on the policy. And one example I gave in the last slide was where there's a life policy, and for example, someone might be in poor health and decide to sell that onto a criminal third party in the black market, and there is a market for that. Again, that induces and creates a problem with money laundering offences. And then product design includes significant fees, penalties around those withdrawals. They are life products that are seen in the market which are potentially open to exposure of anti-money laundering offences. Looking now to the the risk-based. So we look at here. So the key thing about what one needs to look at for the insurance and reinsurance industry is essentially around the product type, the service and geography of that product. So what I mean by product type is if it's a life product with some investment risk, that would tend to be more higher for money laundering offences. If it's in a category or a geography where Rima quite rightly raised the sanctions point. So if it's in a country that's a sanctioned country, or it's on the Financial Action Task Force grey list or blacklist or the OECD list, you should be aware that that's a red flag in terms of the geography of the cover. And then, of course, the customer type is also very important. Who are you dealing with? Are you dealing with a high net worth individual who might want to take out, for example, Keyman insurance for no known reason, and it's an unusual proposal form that you receive, and you look to underwrite the risk? That's when you would want to look at the red flags around that. Where's the individual based? Where is the risk based? What is the type of product? Is it slightly unusual? Is the premium payment very high? Is there an exposure or likelihood of a refund? So those are also very important. And then we look again, as I mentioned, the customer is also needs to be looked at, and we've looked at here. If you look at low risk examples in terms of identity documents, passport, utility bills, as opposed to high risk where you don't really have any proper identity, or an identity has been used by a third party acting for the insured or the beneficiary. Again, those create risk problems for money laundering. And where no third parties involved, that obviously reduces the risk. Where there is third parties or deposit payers and controlled gatekeepers, that's also an issue. And then we look at the customer is living in customer is a large publicly traded company. So we look at the nature of whether it's a traded company on an exchange, in a public domain, like a company's register. That reduces the risk. If it's an individual and we don't have much information what's through a third party, again, such as the example we've given here is a larger company with very complex structures and may have nominees, so we don't really know who the ultimate beneficial owner is, and Rima raised that quite rightly. That's something you'd have to check out, and if that proves that you can't find who the ultimate beneficial owner is, again, that would produce a red flag to some extent, and you would need to make sure that you carry out your risk-based approach and systems controls to make sure that there is no risk with the organisation. So I've just quickly gone over those practical points on products, customers, and geography. where those risks are, and really wanted to sort of thank everybody for listening, and also my colleague Rima for her very detailed analysis. I think we're going to take questions now.
Yes.
I'll hand it back over to Rima.
Okay, very good.
Sorry, Rima, Simon, we are unable to hear you. Maybe just one of you can mute. Sorry, Simon, can you please, yeah. Yes, we can, yes, we can hear you, yes.
Okay, very good. Can you hear me as well?
Yes, it's perfect, yes.
Okay, perfect. We have received a lot of questions, and they are really, I believe, they are all important and relevant in the context of in the context of our discussions. I believe we don't have much time to go through all the questions, but I will try to answer the most relevant ones, or the ones that are relatively important or could be relevant to everyone. And just to note, anyone who could have questions following that, you can email us directly, and we will aim to send you answers to whatever questions you may have in this context. Okay. One second, I'm trying to open the question box. Okay, I will start by addressing a question to Simon. Simon, we have received questions on the difference between risks faced by general insurance companies compared to health insurance companies. I know that we have highlighted that health insurance are the highest risk, sorry, that life insurance sector is one of the highest risk when it comes to insurance sector. What about when we compare life to non-life? How do you see this from an AML perspective?
Yeah, so generally, as I mentioned in my part of the presentation, and also as Rima's mentioned, that life policies, because they have an investment element, tend to be more prone to money laundering. The example you specifically given to medical, it's quite rare that you see, in my view, money laundering being facilitated through medical, but I actually have seen a case where that has been done through a family policy and a demand for an immediate refund. So it does happen in medical as well, and to be frank, it can happen in all lines of business, even on all risk property, for example. But what you would need to focus on essentially is which market or which product line it tends to come up more with anti-money laundering, and that tends to be life, because it has that investment element that one can use either to get facilities or loans against, or surrender the value and then change ownership quite quickly. One of the examples I did give in, so for example, in a life policy, one could surrender the value as against a loan, and the asset value in that surrender value, as I would say, would be to pay off that loan. So there's not much money laundering checks around that, and that's just one example. In terms of other products, I mean, if you're dealing with large corporates on an all properties risk, for example, or a constructions all property risk, something of that nature, then the risk is minimal. So I think that's our view would be you would need to categorize the lines of risk that you're dealing with. But certainly, as I said, it can happen in medical as well.
Thank you, Simon. I think this is very useful. Another two questions we have received. What are the CDD KYC obligations of insurance brokerage firms to mitigate AML CFT risks? Basically, this is a very comprehensive question, and if we want to answer it properly, it's going to take at least 1 hour. But what I can tell you that's more relevant in the context of intermediaries is whether or not they receive money from clients. If they do receive money from clients, and I know that this may not be very relevant to non-reinsurance brokers, the risks could be, to a certain extent, medium. But again, this depends on the nature of business they do, what kind of brokerage they handle. Do they broker live or non-live? What kind of customers do they deal with? Do they deal with corporations or do they deal with individuals? And usually from the perspective of insurance companies, dealing with intermediaries could be a high risk, because this is one of the common ways criminals use to hide their identity. So instead of going directly to the insurance company, they work through various intermediaries, and this is where the risks are extensively high. So there is no straightforward answer to this question, because this will involve doing a proper business risk assessment over the company itself. What do they do? And eventually put in place appropriate CDD that cater for the nature of clients they deal with and all other areas that we have spoken about. The other question that I believe is also very important is in relation to new insurance products, where they need to be approved by AML officers, and what should be included in such documents or certificates. And this is very relevant, because the law, and I'll explain why this is required. Basically today, all of a sudden, financial institution insurance companies should go through the money laundering reporting officer or the compliance officer to get whatever new product approved. And there is a reason for that. Legislators usually are very concerned that new products could involve exposure to AML risks that are not evident. So you don't know until you try, until you see how this product is implemented, is being sold, is being purchased, the after-sale support, and so on and so forth. All of these details are very important. How do they market it? In what jurisdictions do we market it? Whether it does expose the company to new risks. For example, I'm a company that only do life insurance, car insurance business, and all of a sudden I have a new manager on board who is going to expand my license, acquire a new company that does life, and so on and so forth. Obviously, I need my money laundering reporting officer to do the appropriate checks and update the regulations, update the business risk assessment, update the policies and procedures to match the new risks that are highlighted. What is generally included is not in the certificate, but rather the job of the compliance officer is to look at this, see whether or not it exposes the companies to new risks, and put in place appropriate measures to do that. But before this, they need to go and check with the management, because the management will say it's not worth it to introduce this product and pay all of these monies on compliance, or spend this much money and effort and resources on compliance. So that's why the assessment is very required. There is also one more question: how AML applies to insurance brokerage companies, and they do apply on insurance brokerage companies in the context of they need to do that basic customer due diligence requirements and all of the requirements needed. Obviously, the exposure is not as critical as exposure to insurance companies, so we cannot compare what an insurance company should do versus what an insurance brokerage company should do. Nonetheless, they have minimum obligations that they need to meet, and basically these minimum the obligations are uniform across all regulated companies. But what differ is the extent of details they need to go through. So, for example, for insurance companies, the CDD procedures should be extremely comprehensive, extremely detailed. The nature of documents extremely lengthy sometimes, or the nature of information collected could be very tricky, like source of income, bank statements, and so on and so forth. You cannot do the level of risks is different depending on the product. From an insurance brokerage perspective, the procedures could be much more simple in terms of what they need to do, especially when it comes to dealing with clients, training their people, the overall system they need to put in place. So the amount of resources spent on compliance between an insurance company and insurance brokerage is totally not to be compared, but the main highlights are very similar. So I think these are the questions we received through this. We have also received a lot of questions on from various participants. Do we still have time? Do you think there is time to answer some of these questions, Lucy?
Rima, I think maybe you can take, if there are any that you think are really important that needs to be addressed now, or some of the questions can be addressed offline as well.
No problem. I I can go on for another 2 minutes. Just try to answer as much as I can.
Yeah, I would leave it to you. Otherwise, we can always address it post-session as well if you'd like.
No problem. I will just answer like the major ones, which I believe are relevant to what we have discussed today. One of the questions, for example, at which stage of insurance is AML the most critical to avoid any adverse legal implications? Prospecting, underwriting, or onboarding? This is very critical and very important. We need to differentiate, as I said, between two types of screening. We do AML screening and we do sanction screening. When it comes to AML screening, it's very important to do this before, like, or when we onboard a client. And by onboarding, I mean when we accept to consider doing business for a client, when we accept them as a client, not at the time when we underwrite. Before that, usually first we accept the client and then we underwrite for them. And at the time of the onboarding, we need to go through the AML checks and the sanctions checks. For the underwriting, it is required that usually there is a very minimum timeline between the onboarding and the underwriting, unless it's a recurring client. It's a recurring client, you do the onboarding once and then you do the underwriting regularly whenever that's needed. For this type of clients, you need to assess. High risks should be screened every 3 to 6 months. Medium, every year, every 8 to 12 months. Low risks, you can delay the checks to every year, every couple of years, or so on and so forth. So this is how we need to deal with. Specifically for sanction screening, at the time when we pay a policy, it's very important to conduct the sanction screening. Second, is beneficiary screening mandatory at the time of issuing the policy and payment of claims? And what details needs to be captured? Beneficiary screening is not totally compulsory, but it's required if you don't want to be a breach. The problem is the law does not tell you that you are obliged to do this. They tell you if you don't do it, then you will be subject to prosecution. So that's why it's very important